Good evening, everybody. Thank you for coming. This is our meeting of the Physical Services Committee. And if Legislator Crowley would be so kind as to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Roll call.
Legislator Castellano.
Present.
Legislator Crowley.
Present.
Chairman Elner.
Here. Okay. Okay. First order of business, I'd like to move to accept the minutes of the previous meeting of June 10th. Do I have a second?
Second.
All those in favor?
Aye.
Okay, Mr. Tolman, if you'd be so kind as to come up. We're going to be discussing recommendations made by the Ag Board for inclusion of a number of parcels to the Ag District. I see we have some people here. Depending upon how we're going with the meeting, I may be limiting discussion to 3 minutes for, 3 minutes against. We'll see how it happens. So Neil, please get us started.
Sure, thank you, Mr. Elmer. Neil Tolman from Putnam County Soil and Water and Secretary of the Ag Board. So we're here to review the review by the Ag Board. So we've got 15 parcels, 9 applicants, reviewed by 11 members of the Ag Board, and now I understand it goes to you, and then we decide how it goes from there.
Right, and we'll do one at a time, please.
Okay, so we'll go through them one at a time. And I did bring a couple of statutes with me. Did we get the 2 slides that I forwarded? All right, so we've got we have two statutes here doing all the heavy lifting. So the first one is, these are the elements that we're supposed to consider when reviewing ag district applications, and so we're going to be referencing these. There's 1, 2, 3, 4, 7, and they'll come up in bits and pieces, but there's a couple of them that we're going to be referring to probably a couple of times. And then we have a second statute this is from Ag and Markets, 25 AA 30123, and this is going to come up a few times. And this refers to how much for horse boarding operations. So before we get into it, I think it's worth noting that the Ag District went through, our resolution went through in 2007 and Ag and Markets amended the AML 25AA in 2011 to include equestrian operations. And our statute stayed the same. So this is going to come up during this conversation. And but just so you know, the rules changed to accommodate equestrian operations in 2011. We're still referencing the statute from 2007.
If I may interrupt for one thing, there is an addenda, there's an additional which I'd like to accept. It's a memorandum from Commissioner Morosa, which is pertinent to these things. So at this point, I move to accept number 4, the additional. Do I have a second?
Second.
All those in favor?
Aye.
Additional is accepted.
Okay. So we'll take the first application. This is Bob Lena of Angry Goose Farm in Kent. And this was a heavily encumbered farm. We have 2 parcels. One's 115 acres, the other one's just under 40. And Mr. Lena is heavily encumbered under a easement from the EPA from, 2001. He took the parcel subject to the easement. Unfortunately, and he wants to run a horse boarding operation. and he actually already has one sort of going already. Unfortunately, the easement restricts the number of horses to 6. And if we can go ahead, we will go back to the other slide. Yeah,
we have a requirement of 10.
We have a requirement of 10. And so that was kind of the end of the conversation. And we said, you know, his remedy is really to go back to the EPA and look for a remedy there to see if they can make a change to it. You know.
Okay.
But there wasn't a lot we could do about it at that point.
Okay, for the record, what was the recommendation of the Ag Board on this parcel?
Was 0 yes and 11 no.
Okay. Anybody have any questions on the committee of this parcel? Any other members of the legislature? Anybody in the gallery? Be that as it may, I make a motion to not include this application in the agricultural district. Do I have a second?
We have to make a motion on this one if we don't include it? I'm just curious.
The chair, I believe that Chairman Elner is going to go through each parcel and make a recommendation as to whether or not to accept whether to include it in the district, and those recommendations will then be forwarded to the full for consideration as a final vote.
One by one.
Parcel by parcel.
Right. Okay.
I have a question. If the Ag Board is recommending that this not be placed in the Ag District, why are we discussing it and voting on it? It's not like something we would
Because we're going to have
entertain.
a public hearing, so let's follow the process.
If I may, we can choose to approve it even though the Ag Board voted against it, or we have that authority as a legislative body.
I don't know that we've ever done that, nor
Yeah.
Yes, we have.
why would we do that?
It's
we have.
possible to, it's just saying it's a...
But they're not making a recommendation to go forward. It's 11-0
But we can
opposed.
if we choose to.
Right.
Right, we
that-
can. But
That's
we're
their
making-
recommendation to Physical Services, and now I have a motion on the floor for Physical Services not to include this parcel.
I'll second
in
it.
the ag. Second. All those in favor?
Aye.
Aye. Thank you. Next parcel, please.
Next parcel is Frank Rush Drive in Putnam Valley. And he's got 33 acres that he wants to develop into a Christmas tree farm. And although he does have, we actually ran his soil report next to a functioning Christmas tree farm over in Garrison, and he had very similar soil composition, and but unfortunately he didn't have enough percentage. So if we can go back to the first slide again, then we'll just introduce this bullet point. If you look down, 1, 2, 3, 4, 5, each parcel must contain 50% of prime farmland and/or state-wide important soils which are in the New York State Agricultural Land Soil Groups 1 through 6. So when we run a soil report, there are classifications of 1 through 10. 50% of the parcel has to be in soil groups 1 through 6, and he just doesn't have it. So this is, and nor did he have the requisite amount of activity, let's say, he wasn't really selling anything. There was no, if you look at the first one, look at the first bullet point, are the parcels currently being farmed? Well, not really. So Mr. Rush finds himself in a situation where he was sort of waiting to get in the district in order to start doing his Christmas tree, and there's nothing stopping him from doing it now. He did have a problem with, he wanted to get into the ag district because then he felt that would give him more leeway with the local statute that limited his tree cutting to 3 a year, and he needed to clear a whole field. So he was trying to get into the ag district to facilitate that, where the remedy really would have been with the local zoning board. And that's another thing that we're going to hear over and over, is where's the remedy for what these people are trying to do? As much as we like to support farming, we have to be aware of local zoning laws as well. So Mr. Rush's application was denied, 3 yes, 8 no, for inclusion into the ag district.
Any questions or comments from the committee? From the legislature? Yes, Legislature Montgomery.
Just a little confused. You said it was denied, but 9 members of the Ag Board voted yes?
No, did I read that?
3 voted yes.
3 yes, 8 no.
8 no. 8 no.
Okay.
Legislator Nasarino?
I sat on the Ag Board and the Soil and Water Committees for several years, and I just want to piggyback on what Legislator Montgomery said in answer to Legislator Yonke's inquiry. These are just recommendations from the board. They do not dictate, as an advisory board, what should or shouldn't be passed. This is the final determination rests with the legislature, and this is very specific. So when we look to consider these parcels, it's very clear on what is and what isn't. And a lot of applicants, I shouldn't say a lot, but some, use this as a way to alleviate and override local restrictions on zoning boards. And we certainly have to be cognizant that their application is not disingenuous to override local zoning and restrictions within their municipality.
Thank you. Legislator Sage has the
I have a
floor.
question regarding the specifics. You said in reviewing the parcel, grades 1 through 6, it's required to have land soils in grades 1 through 6, but you said it had land grades from 1 through 10, and that excluded it.
No, he didn't have the. I'm sorry,
50% of the soils must fall into
So-
categories 1 through 6.
Legislator Sage, the way this was presented was as a Christmas tree farm. If he had, correct me if I'm wrong, if he had written it as a different kind of farm, it could have been included. But with Christmas trees and hyper-specific, it has to be developed to a certain degree.
Well, not
aside
really.
from the soil and water.
Not really. That's one of your threshold questions, and this is backed up in AGM 2025 and in lots of soil literature. It's the threshold question for anything, is do you have 50% of these what are considered farm grade soils? And that comes out of Soil Survey, Putnam and Westchester counties, and this is put together by the Department of Agriculture in cooperation with Cornell. And I'm just going to go through this once, just lay some of the groundwork. And they have, on page 104, you have your soils. These are there's a lot of language in this about acceptable land soils, viable agricultural land. There's different ways that they phrase it, but this is what they're getting at. These are the soils that they want to see, and they have some
And
variation.
this property did not comply with that requirement.
It just didn't have the requisite soil composition.
Any other questions, discussions? Legislator Nasarino.
Just want to add too, when these applications come before us, does not preclude them from coming back next year once things are taken care of, there's any existing violations, or there's anything that doesn't meet the criteria, and those problems are solved. So there is always another opportunity.
Through the chair,
Yes.
is there a way that they can remedy this? Would that be-
I haven't read anything that suggests there's a way around it, no.
Really?
Putnam County is not, if you think about the topography, because remember, soil groups, they don't just reflect the quality of the composition of the soil. They represent the grade. So it's not just the composition, it's the grade. And what happens is they start to fall out of the category of being good soils when they get too steep. And that's one of the downsides of trying to create farmland, is when you start using land that's not really appropriate for it, you run into erosion problems, and then you run into pollution problems. So you find yourself in the unenviable position of either having to restrict the farming or having runoff and wetlands problems. So you're either like, well, it's the farm or the environment, which is it? Which one are we going to try and side with? So the short answer is no, I don't know of any way around it.
Any other questions or comments?
I just want to be clear, the number one reason for not approving this is because of the soil groups. It doesn't meet the soil group 1 through 6?
That's one of the criteria.
That's one of them, yeah.
Right, that's one of the
That's
reasons.
one of them, and then there were comments that they weren't, had not been sufficiently developed. I mean, he really he had one really nice open field and one up above that he probably could have cleared, but he just wasn't ready, the application wasn't ripe, they would say.
Okay.
Because I'd like to know, really, because of that particular reason seems to be quite broad.
But it's
But
state
there
law.
are, do all of our parcels in the ag district, are we 100% sure that they meet that soil group 1 through 6? No.
I don't know.
So we don't know that, and we could, get criticized because they're not all included. But what I see in this application, I always really like to defer to the town on these things too, even though they're not required to give input. That's not part of the state law. I really like to talk to the town government to find out what their feeling is. And it looks like, according to letters from Supervisor Williams, they, and the code enforcement officer in Patterson, their business plan didn't include things that are already happening on the property. So is it fair to say they weren't being forthright in what was actually happening on the
I
property?
think you might have skipped ahead one,
Number
That's
2.
on of it.
I keep getting the wrong
Yeah,
address. Sorry.
that's all
And
right.
Supervisor Anabi was in favor of this, but she also recognizes that it doesn't meet the requirements. And requirements, we don't have flexibility. That's the law, and we need to follow the law. Legislator Nasarino.
Through the chair, did the board go out and do site walks for each
They
and every
did.
parcel? Okay.
They did.
But again, to your point, Chairperson, are we 100% sure that each ag district property meets those standards? Do we know that for a fact, that every ag district, every parcel in our ag district meets the 1 to 6?
I can't comment
Because
on
if it
things-
doesn't,
I can't comment on things that were done in the past, but this criteria has been around for quite some time, and every one of them should. And all I can go on is what the codes are today. So with that being said, I'd like to move along. I move not to include Mr. Rush's farm in the agricultural district. Do I have a second?
Second.
All those in favor?
Aye.
Next application is from the town of Patterson, 2276 Quaker Road. So you're going to see it, just so we can keep it straight. We've got the first round that was not, we were unable to vote on the first time this application came through, because they had a standing violation with the town of Patterson. They were able to remedy that, they were able to clear the violation, and then we were eventually able to vote. Trying to go back and see what the 2 sides of this, okay. So, again, they don't have the requisite 50% in the ag for the soil, the requisite soil composition. They did have a functioning farm. They did have livestock and some goats and things, but and it did garner a lot of support from the ag board, as you can see. We did get some feedback from Rich Williams, the supervisor from Patterson, who expressed some concerns over ancillary uses, some of these other functions that were going on, parties and events. it came up, it is adjacent to a wetland. You know, when you run a short EAF on these sites, it is adjacent to a wetland, and on a short EAF, they want you to explain what's been done with the mitigation, what's been done to mitigate the potential hazards, and have they been minimized to the maximum extent practicable is the language that they use. And we don't have and maybe this speaks to something of the applicants. I mean, we don't guide the applicants. Hopefully the applicants are, when they're doing some planning, they've talked to some people, maybe some surveyors and things, but we don't have a site plan, we don't have a stormwater protection plan, and there was some concern about that. Although they were running, I would say, a robust farm, it was a respectable effort at that. Unfortunately, it falls outside of what this statute was meant to do. And that was sort of my take on it, and some others, and we'll probably hear from some people supporting this application.
Mr. Tolman, I noticed on the application, it does not indicate any annual gross revenue. One of the other requirements is that it is a functioning business.
You're going back to their original
Yes,
application.
that's what I have here.
For that.
So,
Lack of, however, one of the requisite revenue, if they're over 7 acres, it's $10,000 or more per year.
so we identified at least 2 requirements that are not being met.
Well, yeah, unfortunately.
At least 2. Okay. From the committee, any questions, comments, discussion?
Yeah, no, I'm just a little confused. You guys didn't take a vote on it, but you're not recommending it.
No, we did take a vote on it, and it was, the final vote, 9-2 approved.
So you approved it 9-2
Right,
in your
I'm sorry,
vote.
it's in, yeah.
It's in your backup.
It's in the backup?
So that was the, right, the Ag Board approved it, 9 yes, 2 no.
Any other questions, comments? Mr. Smith, please come up. Oh, I'm sorry, Chairman Yonke.
I have a question. The 7 acres, $10,000. I know that's part of the requirement to get an agricultural exemption.
It's part of the, it is part of the,
I didn't see it on these slides.
There's
Where is that?
Here's the second slide.
that's considered one of the threshold questions along with, no, I shouldn't say that with such conviction. No, I think that might just be.
For a horse boarding operation, it's 7 acres, 10 horses.
They're more specific with the horse boarding operation.
Right, but I don't know
Not
that
with
you need
this.
7 acres and 10,000 on the other.
Not with, right,
Farmland.
anything, you're correct. No.
Okay.
Yeah, correct.
I
Sure.
just want to be clear about
Yeah,
that.
no.
Hello, Frank.
Good evening, Mr. Chairman, fellow committee members. My name is Frank J. Smith III. I'm an attorney at the law office of Schilling & Smith, located at 1961 Route 6, Carmel, New York. I'm here on behalf of the applicant, Ridge Ranch. The property is located at 276 Quaker Road, Patterson, New York. It's comprised of 3 parcels totaling about 113 acres of property. The principals of the farm are Dan and Ariel Hanovich. Ms. Hanovich is here with me this evening. They are a young family looking to establish a lifelong farm in the town of Patterson. On the site, they breed a number of animals, including Scottish Highland cows, miniature donkeys, various goats, and lionhead rabbits. The animals they breed are sold as pets. The Hanoviches, like many others, are interested in a sustainable agricultural lifestyle, and becoming members of the county's agricultural district would help make that a continuing reality. The Agriculture and Farmland Protection Board's 11 members voted 9-2 to recommend them into the agricultural district. I would respectfully request that this committee refer this matter and positively refer them to the full legislature. I'd like to point out that out of all of the applications, there were no unanimous recommendations. 9-2 was the best of any of them, and there were a handful that were voted on, 9-2. A couple of other things that were brought up that I wanted to address. In the applicant's application, it did state the financials. It was number 6, financial projections, and in 2023, livestock sales were about $66,000. So that was included in the application. The other thing I'd like to mention is that some of the items Mr. Toman brought up, we're aware of as it relates to town issues. We're in open communication with Bob McCarthy, who's the building inspector, with Rich Williams, who's the supervisor and the planner. There are no violations on the property currently, and I know that in Mr. Williams' letter, he raised certain items related to events. And I did want to point out that in Agriculture and Markets Law 25AA, Section 308, that's the right to farm statute, they specifically address agritourism in the legislative history. And a brief quote, "Agricultural tourism is being embraced by an increasing number of farm operators as a way to increase diversity and profitability while also helping to preserve agricultural land and open space. It may also serve the purpose of educating the public about the importance of agriculture and its contribution to the local economy, quality of life, and nutrition, and may reduce the friction which sometimes exists between farmers and their off-farm neighbors. It is my opinion that this farm fits squarely within the purpose of the agricultural district law, and I would respectfully request that you make a positive referral to the full legislature. Thank you.
Any comments or questions?
I just would like to point out to, Attorney Smith's point. As I was looking at the comments from the supervisor and the building inspector, and seeing the other uses of the property, I just want to point out our use of Tilly Foster Farm and how hypocritical it would be for us to deny it based on that, because we're using our farm for the same things. Rock concerts, weddings, restaurant operations, all the things. So, thank you for your information.
I agree. Agritourism is a huge industry, especially in Putnam County. I think we used to be called, what was it called, the beginning of the country or something like that.
Where the country begins.
Where the country begins, yeah.
I know
mean,
that
think of
song.
hay rack rides, pumpkin picking, apple picking, all these farm industries that bring people up and bring money to Putnam County. I think that's the purpose of having it into an ag district. So I'm certainly not against that. Probably not a big national party, but agritourism is a huge industry, and I fully support that.
The problem that I see, well, first of all, this committee is just making a recommendation. The full legislature is going to vote on this. And I'm trying to go by the letter of the law on this. It seems to me that these people are on the right path, but I don't know if they're there at this time. I mean, there are requirements, and I don't know how much leeway we really have of these requirements. I mean, it sounds like they do have a viable business. They included that in writing, not checked off on there. They did have a zoning violation. And is this property zoned commercial or is it zoned residential?
It's zoned residential.
And putting them in the agriculture district will prevent them from being subject to residential zoning codes.
Depends on the town, but yes, there's a certain amount of protections that come with it. Some of them are tort-based and other ones are more practical measures like building codes and things of that nature. But yes, there's certainly incentives to get into the district.
From the walk and the observation, were there any codes that you saw that may be challenged?
Well, yes, I'm a certified code enforcement officer, so I can't not see things. But for me, it goes back, and I've had this conversation, and you're at a juncture when you have people trying to, and I get it, I so get what they're trying to do, but this is not your statute, and this is not the land that the statute was meant to protect. They're very clear that they want to protect agricultural lands. This is built on very steep land. We don't have, again, we don't have a site plan, we don't have a stormwater protection plan, all these things that I wish were in place so we could help them along. But without that, it's really hard to, especially again, being close to a wetlands, which gets pointed out in the SEAF, so we can't ignore it. And so I think the legislature, I think you're at a juncture where you either, because once you allow somebody in, this particular applicant has 3 parcels totaling 113 acres, 10% of which is considered soil groups 1 through 6. So we're an advisory board. I am definitely not in the majority on this, but you know, I'm here to give you advice, and advice is to stick with the statute, because if you deviate here, your equity's going to, you know, equity being what it is, then it's basically not going to be a rule anymore. And then you run into the environmental concerns. Like, so again, the county is not in a good spot. You're either going to come across as being hard on farming or hard on the environment, one or the other. Because once you start allowing this kind of development and on steep slopes with shallow soils, you run into an environmental problem.
Before I recognize Legislator Sage and then Legislator Crowley question, there is something, if I recall, regarding when you're near wetlands and or a stream. How does that fall into this property?
Well, ideally, you'd have even, you know, they would have, a lot of this could get worked out at the local level. Nobody's telling them that the county's certainly not telling them that they can't farm. We're just saying we can't
come into the district.
We can't come in, we can't. I mean, there's not much room for a workaround here, so.
Legislator Sage.
My issue is with the board voting 9-2 to accept it. And then, I mean, that's our advisory board, but you're saying the opposite, you don't. So was this not discussed at the agricultural board?
It was discussed.
And why would they vote 9-2 to accept if the soils weren't there?
I think it works like, we all wear, a lot of us wear glasses. We know when you go and get a pair of glasses, they put that big machine in front of you and they hit the levers and everyone. I think everybody's got one of those in front of them. And we heard lots of good support at the meeting, and people, I get it. I mean, I'm not without, I don't want to say sympathy, but I mean, I get what they're trying to do. It's just, this isn't the statute. A lot of this needs to get worked out on the local level.
Legislator Crowley and Legislator Young.
Are you suggesting they should have a secret done through the town to check in?
I don't know. I just don't know how. I just don't know how to accommodate them given this statute.
Legislator Yonke, Legislator Montgomery.
This particular farm, Neil, how long has this farm been in existence?
I think they've been operating 3 or 4 years, they said.
Now, the statute, in your opinion, was it meant to protect existing farms or encourage new farms, or both?
Existing farms. In fact, there's no, I have yet to see any language in anywhere in 25AA that talks about creating farmland.
Okay.
And in fact, if you do, I mean, there's no shortage of agricultural law review articles talking about the dangers of creating farmland on inappropriate soils due to environmental concerns.
Because just for the record, I attended the voting meeting of the Ag Board, and it seemed like people were kind of all over the place, and most of, if not all of the proposed applicants were new farms.
Mm-hmm.
Okay.
Legislator Montgomery.
I think we're getting ahead of our jurisdiction here. I think the purpose of the Ag Board and the Ag Districts is to support farming in Putnam County. And when we start talking about jurisdiction over the wetlands and seeker, that's not our jurisdiction. That will fall under the town's purview, and they will impose those codes. Here, as I said, you know, if you look at documents from the state on ag districts and our role in that, I don't believe it is to go as far as imposing the town code and seeker and wetlands. I think, you know, we can certainly cite those things, which we do in all our literature here, but I don't think that's in our purview, and I think it's a slippery slope to step into that.
Legislator Young.
I think there's a difference between encouraging farming and protecting existing farms. Okay, and if the statute is to protect existing farms, we need to be mindful of that. We also need to have respect for the towns and their codes.
Well, the residents.
And the residents nearby. I'm in favor of farming, and it might be that these farms have to start from scratch and grow to become a bona fide farm, to then become protected by the ag district. And it sounds to me that's what the statute is meant to do.
Yeah.
Frank?
The ag district law very clearly is to promote farming and agriculture. And if that's the case, and the only existing farms would be included, that just doesn't logically make a lot of sense. We want new farms to come in. There aren't a lot of new farmers. It's ordinarily a family business.
I
Beyond that,
respectfully disagree with you on that, and with the advice that I've gotten. The ag laws are designed to protect encroachment of farms by residential neighborhoods. So that's where, in my mind, we absolutely differ.
I think we can have a disagreement on that, but I'd also like to point out that items such as an EAF or a site plan, those are town-imposed regulations. And if there's no reason for my client to have required an EAF or a site plan, then it wouldn't be done. It's not part of the county's agricultural district application. It doesn't ask for that. If it did, everybody would go and get one. So that was just another item that I wanted to point out.
If I may, we have an obligation to any parcel that we want to affirm or want to approve and send to the state needs to be accompanied by a SEAF. So we would be the one preparing the SEAF. So my point was it's difficult for the county, I think, to make that step and deliver in good faith, a short environmental assessment form absent a site plan or a stormwater protection plan, specifically question 13 on the SEAF, which asks you to explain why there's a check, and the check goes in there automatically on an SEAF. You're near a wetlands, and they automatically check yes for you. And you need to explain what's been done to mitigate the environmental impact to the largest degree practicable. And that's not easy to do when you don't have a site plan or a stormwater protection plan.
I don't disagree with that. It's just like the chicken or the egg here, right? I don't think it's fair to have it held against an applicant that they haven't had an EAF done because the town hasn't required it, while noting that an EAF will be done when being referred to the state. The other thing that I wanted to point out is that in the recommendation from the Ag Board, there was no affirmative decision related to the soil setup. It says, quote, questions were raised concerning the applicability of the resolution number 139 requirement that each parcel must contain at least 50% of prime farmland and or statewide important soils, which are in the NYS Agricultural and Markets Agricultural Land Soil Groups 1 through 6. So it does appear that there is some ambiguity there. And again, I think it's this board, or this committee, I should say, that would refer it to the full legislature and would allow for a vote there.
Just so you know, it will go to the full legislature. All that we're doing is this committee is making a recommendation. Actually, prior to going to the full legislature, there will be a public hearing. Now, if you raised the point, do we have a soil report for this parcel?
I have soil reports for every parcel.
Did this parcel meet the soil
No,
requirements?
sir, it did not. This was, again, it was, you had 10% of all, two of the parcels had 0, and then one of the parcels had 4.4 acres, which gave us roughly a 10% of the parcels combined had the requisite soil composition.
And another question I have, is a donkey considered equine?
I believe it is.
And how many donkeys were on the property?
I don't remember. I mean,
The reason I'm asking the question is, per statute, there needs to be a minimum of 10.
no, that applies to equestrian boarding situations.
Well, that's what I'm saying, equine, equestrian,
No,
that's
no, I
gray
think-
area,
yeah,
legislator Nestorino.
I think it's very important that the legislature adheres to the statute, because if we deviate from the statute, then we're setting a very bad precedent that could potentially have very significant adverse effects on this whole process in the future.
You have something?
I think that, that they need to figure out some things and go back to the town and get some questions answered at this time, I feel. Because there's a lot of questions that are unanswered and some things that don't meet the qualifications.
Okay. With that being said, I'm going to make a motion to recommend that this parcel not be included in the ag district. Do I have a second?
Second.
All those in favor?
Aye.
The next parcel is in the town of Carmel, 241 Washington Road. This is an application seeking to be a commercial horse boarding operation. The majority of the board supported this application, citing a use consistent with the neighboring parcels and the reputation of the applicant. Other members of the board cited concerns over the absence of existing infrastructure or a horse boarding activity.
I looked at this one myself pretty good detail, and I am familiar with Mr. Hasbrook, and for a bad cliche, I have to say, it looks like we're putting the cart before the horse. There are not 10 horses on this property at this time, so it is not functioning as necessary. So that's one of the major concerns I have, which is why I would recommend against inclusion. Any other questions, comments? Yes?
There's also no infrastructure on there. There's a pending subdivision. And currently, right now, they want to do horse boarding. Carmel, within the town limits, only allows 5. So there's also that.
Yeah. Supervisor Kazari did provide a letter indicating opposition at this time because some matters had to be taken care of. Any other questions, comments? Okay. So I move to recommend against putting this parcel in inclusion. I recommend to not include this parcel in the ag district when we go forward to the full legislature. Do I have a second?
Second.
All those in favor?
Aye.
Aye.
Town of Southeast, 300 Foggentown Road. There are 2 parcels. There's a parcel in southeast of 56 acres and another one just over the line to the north in Patterson, which is 22 acres for a total of 78 acres. Applicant seeks inclusion to the ag district as a farm raising free-range pasture-raised protein. The application has 2 parcels in it. Under Putnam County Resolution 139, the agricultural viability is gauged by several factors. We can reference that. Here there was, maybe if we can go back to the other slide, please. The question, are the parcels currently being farmed? So the board felt that they were satisfied with the farm operations, and we're following agricultural and best management practices, which is another requirement. Opposition to the application was based primarily on 139, consideration that the parcel was adjacent to, this is one that we haven't referenced yet, the parcel is being adjacent to a sensitive natural resource. So there's some bells and whistles that went up with that, and there's a reference to it being adjacent to a Class C stream, which goes into the Bog Brook Reservoir.
I also note that on the soil report here that most of the soil was outside of 1 through 6, and it appears that 10% met soil criteria 5.
No, this one fared a little better. We had the parcel in southeast reached 40%. The Patterson parcel reached 7%. 7%.
Okay, so it's still way below.
Still close, but not there.
Any comments, questions from the committee, fellow legislators? Mrs. Eckhart, please sign in.
I can't do both at once, I'll sign in afterwards. Good evening, everyone, nice to see everyone. Thanks for letting me speak. I actually have been out to the farm, and I did sit in on the ag meeting, which was really helpful and very interesting. I do have concerns because of the stream, and I know Mr. Tolman had talked to me about inspecting, because there were pigs that were rooting, they were clearing the property right alongside the stream. And I don't want to put words in Mr. Tolman's mouth, because I think you were really helpful, and you were saying you were going to suggest that the stream be fenced. Is that correct? Am I right on that, or how?
Well, I think my comment was that I was really hoping that we would have a stormwater protection plan, or something, or a site plan, give us something so we know what we're vouching for.
Yes, because there were, my question to the chair, through the chair, would be, when does a violation have to be in place? Or in other words, when you go to vote, when is the, I know you're voting tonight, but when will the full-fledged vote on this, accepting this?
First Tuesday. August
The
12th.
August
First
Tuesday.
Tuesday.
August fall.
Okay, because you mentioned another public hearing. Is there another public hearing?
It'll be just prior to the full legislative meeting.
Okay. And if there's a violation in place at that point, do you consider it, or?
No.
Okay.
Just anything.
I'm sorry?
Through the chair, who's ever doing the review at a given moment has to apply the criteria. So when the Ag Board does their review, if there's a violation, they have to take that into consideration. If one develops between the time the Ag Board does their review and the Legislature does their review, the Legislature has to consider it. So it's an application of objective criteria, no matter what time, whenever it's being done, those are the criteria that have to be applied.
So it proceeds as if there were a violation later on.
Right.
Yes, and however.
And similarly, when a violation is cleared, like what happened here with one of the earlier parcels, there was a violation initially,
Yes.
and it was cleared, and the Ag Board re-met to reconsider it because that was no longer an impediment, because luckily it fell within the Ag Board's review period.
Okay.
However, if there's a violation at the time we're going to vote on it, that criteria means that it's defective, and we have to vote in the negative.
All I'll say is you have to apply the criteria stated in the resolution.
Okay.
I'm sorry. Go ahead.
No, okay. And I'm glad everyone's sitting down, because I have to agree with Mr. Yonke, Legislator Yonke, who was there at the meeting, and it really was, the committee it was really interesting. They were kind of all over the place. I thought it was, which is a good thing, everyone was questioning different things. But I do have concerns about this because of the storm water, and they can continue to farm, obviously, if there are no other violations, but because of the stream and the pigs and all of that, I do have concerns. And it's right next to the Bog Brook Conservation Area, so I have concerns about that as well. So I just wanted to express those, and thank you for your time.
Thank you. Any other questions, comments? Legislator
Well, just so everyone is clear, when an application is sent in for consideration, a notice is sent to the code enforcement officer and to the supervisor, so they're well aware, and they do respond to whether or not there's any existing violations at that time. I'm not quite sure as this progresses how you could ascertain whether another violation popped up, because I don't recall that they go back to the town to reassess the situation. So maybe you could answer that.
No, we wouldn't. It's not part of the mechanism.
Any other comments? Legislator
Just one,
Yonke.
and this is in my district. I met with the owners. They claimed to me that they met with the DEP, and the DEP was fine with the stream running through the property and them doing their farming near the stream. They represented that to me.
Legislator Crowley.
Do they have any backup to provide to us that happened?
Just verbal conversation.
I think when we were addressing the small stream issue and the protection of small streams a couple of years ago or a year ago, it was noted that the Soil and Water District does that for the county. So any mechanisms that we have to protect this small stream, we do that. That's the whole reason that law didn't pass, was soil and water districts claimed that they have the authority to do that anyway, and we don't want to hand it over to the state. They have that enforcement, and that's what we claimed as a county we were doing. So are we doing it or not?
What
If I may,
class
if
is,
I may, the
before
Class
you,
C's, the-
what class is this stream?
It's Class C,
Thank
right, Class C stream, which means that any sort of work that you have, the good part is that it's a Class C stream, which means if you have any work to do, or it's all done on the local level. So it goes to the municipality. It doesn't, the responsibility doesn't go to the county. It goes to what that legislation wanted to do was put it under the auspices of the DEC, which would have been a whole different way of permitting. And so it's at the local level. The county doesn't. The county's available, soil and water certainly accountable, or available for help, but we don't orchestrate the application process.
Legislator Sage?
So there's nothing from the town regarding a Class C stream violation for
No.
this particular property?
No, we just, it was just part of my observations. And we have the third bullet point, farmland parcels within or adjacent to a critical or a sensitive natural resource must have a conservation plan or something put together by soil and water. And it's just a lot of activity very close to a stream going to a reservoir. That was the concern.
But there's no current violation?
No, ma'am.
And the board voted 9-2 to accept it?
To accept it. And then there's the 50%. They did not have the 50%.
They didn't have
Soil.
50% soils.
Soil. They did not have the requisite soil content.
Does the stream, is it in one or both towns?
Just one.
Which town?
That would, southeast.
Okay.
It would be great to have a letter or something from the DEC if they had a conversation, just to back that up. I think that would be.
I said DEP.
Was it DEP, not DEC?
I believe it was DEP.
Okay,
Yeah.
okay, thank you.
Legislator Montgomery?
I think it's important to note for the public record that our planning commissioner noted the same thing and stated in her memo that she voted for the inclusion of the property after deliberation since the farm is existing, and any potential environmental issues on site that require review that are affecting the New York City water supply should be addressed by the appropriate agency, such as New York City DEP.
And the WAC.
So again, I see, how far is the authority of the county ag board and the county legislature going to take their purview? These
The
are
ag
things that
board-
are under,
The ag board has no authority.
well, the legislature, I said also. So, we seem to be broadening our authority over things we have no jurisdiction over. The DEP does, the towns do, we don't.
If I could ask Legislative Counsel, I just want to make sure I understand this process a little bit better. If on prior applications that we've had tonight, if we vote no, it's still going to the public hearing, and after the public hearing, any legislature at the full could bring it back and try to approve it? Is that what we're doing here?
Correct, through the chair, correct. The committee right now is making recommendations to the full. After the public hearing, the full legislature can always vote to include or exclude any of the parcels on a full vote.
At the full meeting following the public hearing, which will take place prior to the full?
Correct.
All right, I just want to make sure I understood the facts correctly. Regarding this parcel, I will say that I'd like to get a little bit more information about it as well. I did speak to a couple of town board members who had their concerns also, so I thought the town was leaning against it, but I want to do a little bit more investigation. But right now, I don't think we're ready to move it forward, but happy to hear you guys out.
Neil, per code, the legislative council, we have to make a vote on this. This is not something that we can delay, correct? Due to timing, we have to say.
Yes,
Yeah.
there is a requisite time frame for action, and I believe that if it was not done by the August full, we'd be out of compliance.
What I meant by timing is maybe this is not the right year, maybe next year. That's what I meant by timing.
Yes, okay.
Through the chair, can we get Barbara Gross's input
Sure,
on record?
if she'd like to. It is.
I know, but
She's-
to hear from her.
The additional number 4 is Commissioner Baros's, which he was kind enough to do. We appreciate it.
Good evening. I mean, I was going back and forth on this one as well. I ultimately voted yes, as my memo said, because it's existing. I know there are issues with the property. I felt that coming under the eye of DEP and WAC, if they were an agricultural parcel, that some of the issues might be addressed. Either way, they're an existing farm, they're going to continue farming. So, I mean, that, and as far as the stream, Class C is the lowest level of stream. Until recently, it wasn't even permitted by DEC. So, as far as the sensitive natural resource, I didn't feel like that met the threshold, so.
Okay. Just, yes, Legislator Montgomery.
There's a lot of papers here. Do we not have a comment from the Southeast Town Board?
Not that I know of, just my conversations with them
Did
on
they
my
not,
part.
did they,
I heard not, I didn't hear anything
they
back.
were-
I think I got a notice of no violation from them.
Before I make a vote.
And I'm sorry, but Supervisor Williams also signed off saying he didn't have any problem
Southeast?
with the other parcel.
Yeah.
Supervisor Durante. Durante, okay, Southeast.
I'm sorry, did Supervisor Durante chime in? I didn't see it.
Not that I'm aware
Okay.
of.
No, I was saying that
Policy.
Supervisor Williams.
That's
Patterson. Because
Patterson.
because there is a parcel that's over in Patterson.
Oh, there is, okay.
There's 2 parcels.
Right.
Before I make a motion, could you please tell me again, did it meet the soil criteria?
No, sir, it didn't. No, it had one parcel that came in at 40%. That's the southeast parcel, came in at 40, and the Patterson parcel came in at 7%.
Okay.
Again, I'd like to point out that I don't know that we've ever held that criteria accountable across the board for all of our parcels. And there's something very ambiguous about that.
Well, that's state law. That's
Well-
where that comes from. So we need to apply state law. People made errors in the past. This legislature can't be responsible, for what happened. But I know
We'll
that-
need to go back and exclude all the others, is what I'm saying. So that'll be the job of this committee.
Potentially. Okay. Yes, Legislator Sage.
I have a hard time with that. How many current, like Legislator Montgomery was saying, nobody's ever going to be farmland in Putnam County. How difficult is it to have 1 through 6? And I think the purpose of having an ag district is to encourage farmland. They have a business plan. They have, back when I was on the ag board, when Lori Taylor was the head of the ag board, it was about promoting farming. It was about promoting a business in town. It was about protecting open spaces and land. And I feel like it's a technicality that you're just throwing everybody out. And people who are really trying to farm and trying to keep our food source near to where we live, are we just going to farm all of our food sources out to God knows where, instead of having farmland, eggs, poultry, chicken, things close to where we live. And I think we're really throwing it all out with this little technicality of 1 through 6. I understand, it's state law, I guess, 1 through 6?
It's a derivative of state law.
How much of Putnam County is in 1 through 6? Can we just
Not
say
many.
nobody can
No.
apply for a farm
No,
district?
and
Because
I-
Putnam County has no
And I
farmland?
get the concern, but when I, when I was thinking about this, you have to think, what was the statute designed to do? And it was designed to protect existing farms and agricultural farmland.
I do
So
agree.
it is absolutely possible that this statute, and it's the way it's written, I mean, my problem with this, I mean, I'm a statute guy, and each parcel must contain 50% of prime farmland, and there is a definition for that. So that's, I mean, unfortunately, I think that's sort of where you're at with this
The
law
other thing
as
is,
it
we're
applies
only
to this
debating
district.
inclusion. Any action we take here doesn't prevent this farm from continuing its operations. It can continue to
But
farm.
they just can't be protected by farmland protection, so we can't protect these little farms who are providing food and
But if they're not in
services
any
to our-
violations, then protection wouldn't even be necessary because everything's working. Legislator Nasarino.
Well, I think Commissioner Barbosa's recommendation really should have some weight in this consideration. And as you just said, Chairman Elner, this is still going to operate as a farm. So the consideration for it's not going to change the impact one way or the other. So the soil is at 47% in the cumulative of both parcels. Whether or not that's really going to clinch the deciding factor is something that we really need to weigh in on. And Barbara had given her input and her recommendation.
Barbara, did you take into account the soil requirement with your recommendation?
I did. Partially, I looked at the type of farming when I looked at that, and I know it's not in the statute, and this was just me personally. I see that as more important when you're farming vegetables or growing something in the ground. If it's a commercial horse boarding operation or animals, the soil composition is important for steep slopes or wetlands, but not necessarily the composite for prime growing, so.
Okay. Well, I move to recommend not to include this parcel in the ag district. Do I have a second?
Second.
All those in favor?
Aye.
Down at Putnam Valley, must have, I'm running out of water, so we're gonna speed it up. I should have bought the good, yeah, like one of those. Thanks, Ed. Down at Putnam Valley, 221 Oscawana Lake Road, Big Red Farm, total acreage is 67.05. Applicant seeks inclusion as a commercial horse boarding operation. The board was generally supportive of the application, citing use consistent with the previous owner and neighboring parcels and having demonstrated adequate boarding capacity of 10 horses. Questions were raised about the proposed development being inconsistent with existing zoning laws, inadequate turnout as far as inadequate turnout areas for the horses, and there were 3 horses being boarded at the time of the site visit. The board voted 9 yes, 2 no to recommend inclusion into the district. Thank you. If we can maybe get the other back and forth here.
So the key to this is you must have 10 horses on the property in order to be included in the ag district. So this property does not meet that requirement.
Right.
Any questions or comments from the committee, from the legislature?
I have a question. We have 3 properties this evening that the Ag Board recommended 9-2 vote, and this is one of them. So this recommendation, and you said you do think of the difference, this is for sporting as opposed to farming vegetables and chickens. But why do we have 3 properties that there are 9 votes positive? I'm confused.
The first application was denied, 11-0. 11.
Yeah, I'm talking about the other ones.
And there's 2 others that were approved, I believe, 9-2.
Yeah. So I'm a little confused, I think, because, you know, we do rely on the Ag Board, and there's 9 affirmative votes.
I think
Again, that's why I prefaced the conversation with there's 15 parcels, 11 people on the board, and I just report what the vote was.
so. This property has 10 stalls for the horses. They had 3, I think they were personal horses on the property, as well as chickens. And goats, sorry. To meet the criteria of the horse boarding, they do need 10. Personally, I felt currently they had 1 field available for the horses. I didn't feel that tomorrow they could have 10 horses on the property. So I actually voted no. Other people felt that since they had the 10 stalls, that they could, that it should be approved.
And this property had the correct soils?
No, this one had 39%.
I think there's someone in the audience.
Right, I
who'd like
will
to speak.
just go
Yeah,
first
okay.
to the legislature and then to the audience. Anyone else on the legislature? Please.
Good evening. I'm Joey Mancuso. I'm the owner of the Big Red Barn Farm. So a couple of things I would like to address. When the board came to my farm, there are actually 2 large paddocks, each of 1 acre in size, that are there, as well as a large open field. So those requirements, that at least 7 acres are met. It is about 67 acres total. A large part of it is wooded and also has trail area in it as well. But there's more than adequate land for 10 horses, according to law, and according to being a human being that actually cares about animals. Additionally, you know, a larger part of this is because I'm having a lot of difficulty navigating within the town, getting the appropriate permits and things. It's requiring a lot more things than I realized, I'll say. But talking to the zoning officer and the town planner, they encouraged that I apply to become part of the agricultural district because it would help me overcome a lot of hurdles that I need to overcome, basically, to get what I need to get to have the 10 horses in the property. One of which is being a lot of the grading and zoning of the property would require a lot more in-depth requirements if I wasn't part of the agricultural district, as well as a financial burden. As opposed to $1,000 in fees, they told me it would be $11,000 in fees, which is for a horse boarding operation that is not, it's for pleasure, it's not for breeding or racing or anything like that. It was very constrictive. So I have a couple of my boarders here that will be coming. They just require an indoor arena because though I love Putnam Valley, it's a town of rocks, unfortunately. And we do require adequate space to ride and provide, excuse me, provide for my clients. And we have, so I do have the 3 horses, and I have 7 more lined up to come once my arena is built and once the area is graded.
What's your time frame?
As soon as possible.
Can you be more specific?
Before the winter. But that's, I brought them here to vouch for their beginnings.
I reached out to Supervisor Anabi, and she was in support of your application. I just wanted to put that on the record. But here we are with the same quandary. We have to apply the same requirement fairly across the board. So if there's not 10 horses at the time, you don't meet the requirements, which I'm sorry. Any other comments, discussion?
I would support this, being the person who represents that community. I haven't been on the property, but I've driven by the property. And I do believe putting the arena there will give them the opportunity to have the 10 horses and possibly more.
I'm just having a hard time with this whole thing. Now, you also said this one only has 39% soil, so this can't be considered because of state law, and it's a horse boarding situation. So technically, we cannot include this into the ag district. Also, what is the local town? The local town says, what, you can't have 10 horses, you can only have, this previous property, the town board says you can only have 6, and you can have 10 with the ag board, but you can't have 10 because the town won't let you unless you get into the ag board. I mean, this is just like a damned if you do, damned if you don't. Are we supporting farming, or are we not supporting farming? This is just so much red tape, bureaucracy that I can't even. I'm just, these are businesses that are trying to survive in Putnam County and pay taxes, and we're just trying to, I don't know what we're trying to do here. I really don't. Ag board says one thing, I'm just so confused by the whole situation. I was on the ag board for I don't know how many years.
Well, they do have a local remedy. They can get a variance at the local level. It's just, again, I don't like this any more than anybody else. Just the statute says what it says. It was designed to do a certain thing, and there are things that are just going to fall outside the statute. Now, when I began, I did point out that the statute, 25AA, was amended in 2011 to accommodate horse boarding operations, which was not part of the original consideration in our 2007 Resolution 139. So is there room at some point for the legislature to consider an amendment to this? Possibly.
Yeah.
But I would, I would rather see that happen through the legislative process than by making exceptions to the existing statute.
That's a good point.
It just begs the question, we have an ag board that purportedly is qualified to make these determinations, but yet we have a convoluted process here with factors weighing in by not only the ag board, Mr. Tolman, our commissioner. As Legislator Sage indicated, this just really seems to be a dog and pony show going on right now. So are we going to respect the ag board's determination and take that into careful consideration, or are we going to just follow the recommendations as cited by Mr. Tolman, which are founded, but, where does the authority lie with the recommendations? I understand that it's up to this board for approval, but where does the authority lie? If the supervisor is in favor and the ag board is in favor and Mr. Tolman is not, then which way or which direction are we going in?
Karen?
As sitting as the liaison for the ag board, you have 3 people that are representing the county, and then you have other people who are representing farmers and their different
I understand that. I sat on the board for many years.
No. So I think a lot of times when you bring up state law, their love for farming sometimes doesn't see the state law, and it becomes more advocacy at times than activism at times. And that's where you're.
But it would be my assumption and expectation that the members of the ag board are very cognizant of what the statutes are and what needs to be done before they cast their vote.
Okay. Do you have some more question to the Legislative Council? Hypothetically, if we approve, if the full legislature approves a parcel that does not meet the very clear state requirements, what issues does that create?
When you have criteria that are being applied, if they are applied inconsistently, it allows challenges, and this is something Legislator Nasarino actually mentioned earlier on. You are open to challenges that the action of the board on a future applicant was arbitrary and capricious. So, for example, not with respect to any particular parcel, if you allow in a parcel that has 20% prime farmland, when the statute says 50%, then if someone, a future applicant comes along with 25% farmland, prime farmland, and the legislature denies that application, they can bring a suit that the decision of the legislature was arbitrary and capricious because they gave it to someone previously. So that's always the danger in granting an application where the objective criteria are not being followed, because then future applicants could say, well, you didn't follow it for Jones Farm, why aren't you following it for Smith Farm?
Do we have any exposure to the state because we are knowingly circumventing state law?
I don't have a quick answer for you on that, but it brings in the larger issue that these are criteria set by the state. And even our resolution, as Mr. Toman said, our resolution incorporates the state requirements. So if people are unhappy with the way this scheme is working, this is the way the state created it. It's really, you have to implement the state scheme is what you're really stuck with.
That's what my feeling has been, is this committee here, and me as chairman, I have to follow the rules at this point. Legislator Nasarino.
And I agree. I'm just concerned about are the members of the Ag Board trained to make these decisions and have the knowledge they need to make these decisions, because the decisions that are reflected in their vote are not reflected in Mr. Toman's vote nor Commissioner's vote.
Any other?
It should be consistent.
Should be any other questions? Okay. Be that as it may, I move to recommend not to include Big Red Farm in the Ag District. Do I have a second?
Second.
All those in favor? Aye.
Town of Patterson, 550 Route 164, Hidden Hope Farm, applicant seeks inclusion in a combination of agricultural activities, including vegetable gardening, orchards, horticulture, and beekeeping. Under Resolution 139, one of the factors to be considered when determining viability is, are the parcels currently being farmed? The parcel contains a working garden area, however, much of the property has yet to be developed. The majority voted the property was not sufficiently developed for inclusion in the Ag District. Citing Resolution 139, again, other board members felt the enterprise qualified as a startup farm and should be included. It should be recommended for inclusion. The vote was 4 yes and 7 no to not recommend the parcel for inclusion.
Committee, any comments, questions, legislature? Audience? I have one question here, because I noticed it says listed as 18.7 acres, 17 acres farm. Any question regarding setbacks?
No, it did not come up. That was not part of any conversation I was part of.
Okay, and the recommendation was based on, the recommendation not to include was based on soil composition?
Well, the soil composition certainly, that was, they came in at 28%, so some of the concerns had to do with, it just, again, talk about ripeness. It's not exactly a ripe application. They hadn't really developed much of the property. I don't know what they were turning out as far as revenues. There's a lot of steep slopes, a lot of wetlands, a lot of things yet to be determined.
Okay.
I'm sorry, again.
Legislator Nasarino.
Just let the record reflect that Supervisor Williams is not in support of this, noting that it is close to the
I believe,
state wetland Great Swamp, and
I believe you may be in a different, we're on item 7, which is in Brewster.
It's a town of
It is.
My mistake, I
It's a
apologize.
Brewster Post Office.
Got it. So as you were saying, Supervisor Williams has reached out and said
I
he's
was
not
make
in
sure that
favor.
I'm on the right.
Shannon
Yes,
there,
I am.
committee?
Yes, I
my
am.
mistake.
So
Please.
he states in his letter that approximately, the wetlands associated with state wetlands, the Great Swamp, in this area, the property owner is proposing to clear 8+ acres of forested wetland, including areas on both sides of East Branch, Croton River. Is the county really going to support clearing 8 acres of the Great Swamp? So that's a very important environmental consideration that we should not support.
Any other comments, questions? I make a motion to recommend not to include this property in the Ag District. Do I have a second?
Second.
All those in favor?
Aye.
Neil, number 8, please.
I'm sorry, Town of Patterson, 187 Tammany Hall Road. Applicant seeks inclusion as a tree farm. The business plan stating the applicant is growing seedlings out to larger trees and supplying them to clients. They're identified in the application. The grow area was 3 acres, and under 25 AA, land used in agricultural production means an area of not less than 7 acres, used for the preceding 2 years for the production and sale of crops. The majority of the board members felt that the area was too small to be considered viable agricultural land and lacked adequate scale to be included in the ag district. Some members of the board felt the scale was sufficient. The vote was 4 yes and 7 no to not include the application.
Any questions of the committee? Legislature? Legislature.
Is scale considered in the resolution 149? Is that specific in the resolution?
At 139, it's
At 139.
what is the degree of farming activity, and the board felt it was not, they did not have sufficient agricultural activity happening to support it.
Is that based on scale, based on
Well,
what
I'm sorry, if we
product,
can
or
switch it.
based on
Well, it's based
area?
on volume and area and a number of factors. We can skip back.
So
Oh,
this,
sorry.
property had seedlings in some of those shops. They weren't planted, there was nothing growing as far as the 3 acres cleared. It wasn't actively farmed yet.
It was more of a staging area. I think one of the board members referred to it as being more of a staging area than an actual farm.
Okay. I see that both Commissioner Barosa and you, Neil, voted not to include. That was your recommendation. Okay, any other questions? No. I move to recommend that this parcel not be included in the agricultural district. Do I have a second?
Second.
All those in favor?
Aye.
Aye. Okay, we vote.
Town of Phillipstown, 250 Old Stone Road, Pine View Farm, and four different parcels, 2.6, 2.2, 15.08, 17.4. Applicant seeks to incorporate 4 new parcels into an existing agricultural enterprise. The applicant already has another piece, some parcels, I believe they're in Kent, so he's trying to incorporate them into that agricultural enterprise. Board members were satisfied with the scale of the existing agricultural activity and voted to recommend inclusion into the agricultural district.
From what I see, there's no farming activity at this time.
It was reported back, I did not do a site visit on this. I had a doctor's appointment that day, so some of the feedback that we got from the Ag Board that was that, in their opinion, there was sufficient agricultural activity.
Okay. And soil quality?
The applicant had, the 4 parcels, 3 of them had 0% in the soil groups that we're looking for. one of them had 46%. And having grown up over there, I do remember that one parcel on Route 403, I remember seeing livestock grazing there, so, but he still came in at 46%, which I would suggest that maybe, go have your own, have an independent soil report done. At 46%, this was the closest, I think, any, Hasbrook had the adequate soils, but he had other issues. But this was one of the other parcels, this is the one that was closest at 46%. I suggested to the Ag Board that, maybe he might want to consider just making the application for the one district that was very close and supply his own soil report. Maybe he could get to the 50%, but the Ag Board felt that the parcel should not be severable from the rest of the application. So that was sort of the way that went.
Well, how do we make exceptions for some and not others?
You don't.
Yeah.
Any other questions or comments? Legislator Montgomery.
Again, they're not growing anything on this property. It's for an agricultural enterprise to include heritage cows. That property all over in that area has been farmed for centuries, so I'd just like to point that out. All that land there still exists, farms that we have, I think in some of our, we have in our farm, in our ag district. I think it's Saunders Farm and the whole long 9D that. So again, pointing out this issue with the soil groups and how, I guess it's the commissioner who determines it, not our commissioner, sorry, who New York State determines, like, do they really go out and assess these soils every year and present that scale to us every year?
The soil reports are available through a webpage run jointly by the USDA and the NRCS. And it's essentially a trace and click, and that's how you get your soil reports. And that's how ag districts do it. Some of the some ag districts have that plugged into a GIS system, which is faster, but I don't know about accuracy. But overall, it's how the soil reports are produced, and which is why I say, well, when it came in at 46%, it's like, well, okay, well, maybe you do want to. It might be worth your while to go pay a surveyor to, do your own study. The other part, and you're right, that those parcels are surrounded by other farmlands, right there at the base of the mountain there. But those were not the parcels that he made the applications for. The other applications were single-family residences on 2-acre lots, and then another one up at the top of the. Anyway, those is the. And again, the Ag Board felt that there was adequate activity, but unfortunately the soil reports did not.
Legislator Yonkin.
I was wondering, is there any way where we can turn for an opinion to just clarify if there's a distinction between horse boarding, production of livestock, crop production? It seems to me that soil type would go along with the production of crops.
Again, it would, but again, you have to remember that the soil groups it's not just the composition, it's not just the amount of topsoil or the quality of the topsoil or the components. It's also the grade.
Topography.
It's also the topography.
But if you're raising goats, the grade doesn't matter. It shouldn't matter. Am I wrong?
Well,
These?
no, but again, the more you start in trying to incorporate agricultural activity on steep slopes, you start running into erosion and runoff issues.
But we've gone through 9 prospective farms here. If Putnam County soil and our topography isn't conducive to farming, why do we have an ag district? Why don't we just punt and get rid of it?
Well, if it was on a curve, you're you haven't had a lot of activity. I mean, most of your parcels went in 2011, and, I mean, you had 6, 10, 22 going by town here, 34 in the town of Phillipstown in 1 year, 2011. So, again.
I'm betting they weren't held to the standard that we're holding these properties to today.
I don't know. I'm just saying that it is possible under this statute, again, I want to keep saying that, under this statute, it is possible you're going to run out of candidates. But again, that's.
But my question was, can we get an opinion? Somebody to write us and just, somebody from the state that just says that, that this is, it's 50% of this soil type. For all agricultural uses.
Yeah, I mean, you could. I think Mr. Ferrillo is, I think, kind of looks at it the way I do, where the statute is what it is for us.
Do we have an opinion from the county attorney?
If I may.
Well, I was going to say, Legislator
Well, I just want to answer
Okay.
Legislator Yonke's question, if I may, or propose two potential solutions. One, we might be able to pose the question to the Ag and Markets Board, to the state, and see what their interpretation is. There's also a mechanism where a county attorney can write to the Office of the Attorney General for an advisory opinion on a law. So those are two, right off the top of my head, there are two mechanisms that could potentially be used. One would be specific to interpretation of a law, if we had a question about how it applied, but less formally, we might just ask Ag and Markets what their take is on it.
Have you spoken with the county attorney's office over any of this?
I have. I've spoken. I've gotten the okay to engage Andrew Negro, who I guess has given the Ag Board some advice over the years to talk about some of these.
What does Andrew say?
We are just starting the conversation. We just framed some of the issues for him.
Would you bring this to him and see if we can
it's already in the works, and I'm glad you bring that up, because it's not an easy situation, because you could easily get called out for being anti-farming, or you could get called out for not caring about the environment. It's not a good spot. This statute puts us in a really bad spot. So we have to start, I think, for all involved, we'd feel a lot better if we start digging in on some of the key issues, such as we are at the end of the day advocating for a commercial business in a residential zone. That's a problem. That's a problem. So, the 50% and the flexibility, and what are the ramifications of sticking to the 50% rule, and what are the ramifications for letting it go? And certainly the horse boarding, where there was never an adjustment made. So absolutely, there's some things to think about with this statute, and just to make sure that we maybe clean it up and start, and so we head in the right direction. But you don't want to short, that 50%. So there's a fair amount that has been written about. Just be very careful about creating farmland, and that's in a lot of the law reviews that they talk about, where municipalities run into problems, because this statute especially never mentions the word create. It only says maintain, protect, support. It doesn't ever say anything about creating farmland.
Right, that goes back to my question earlier on, so I understand. But I'd just like to get that clarification from Ag and Markets.
It's in the works, and there's nobody.
Gentlemen, I'm sorry, with the back and forth, Legislator Montgomery had a question.
I'm sorry.
I wanted to get back to her, because this is going to go on.
I just, I think it's time to revisit this in detail. That's all I want to say. I don't know if our farmland protection review has been updated. I remember years ago when I was on the town board, or even before, we had it under County Executive Bondi. We did a whole plan with an executive summary and all the data, mission statement of what this is all for. So that was 2004. I think it needs to be updated, as I just really wonder how often these criteria are updated for the soil groups 1 through 6.
Since 2011, the state, this is all come state, Ag and Markets.
Soils haven't changed since then? That's the data we're using for this?
No, not the
No.
data, the
Okay.
statute.
No, the
The
data off the
statute.
website's all current, that's all, again, maintained by the USDA and NRCS.
They're coming out every year and
I don't know, they're,
testing the soil?
Any other comments, questions? Amy?
I mean, back to this particular parcel, it says total acreage in petitions is 546.83. The total acreage recommended is 211.28. It also states that if you take some, you talked about taking certain parcels out so that their soil percentage 1 through 6 would be higher. Is that correct?
right, this was all put in on one application. My comment was, if he just put in for the one parcel, he might have had a chance of getting it in.
So, okay. I'm just wondering what the difference is between the 546 and the 211.
He's existing.
Oh, that's,
He's already in the ag district.
Oh, he's already in the ag district. Oh, okay.
So
no, that's the total acreage and all the petitions.
Total petitions.
All the petitions and then the total, how many
Okay, right,
how many
yes,
acres
yes.
were
I got
recommended.
it, okay.
Right.
So the 211, which is what's from
Nancy, you had your hand up?
just for
Yeah.
clarification, there is already agricultural activity happening on this property?
Well, the board felt they had seen adequate agricultural activity.
And the mission of the Ag Board and of Putnam County is to preserve and protect that activity. So just, I want to point out or understand, because I'm not a scientist, and how this criteria is developed for these soil groups. And these parcels are adjacent to each other, so it's interesting. Is that correct? The parcels are all?
They are.
adjacent? And I want to point out that the town just gave land to a farmer who's farming land adjacent to this to grow crops for the food pantry. So the land adjacent to it can be farmed to grow food. It's just, I wanted to point that out.
Right, but one thing which we haven't touched on is with all this is, once you're in the ag district, there's another step. And if you meet all the criteria here and additional, then it can potentially create tax abatements for the owners. So we haven't touched on this, but that is a distinct possibility. Anything that we do here does not prevent any of these parcels from being farmed and continuing to being farmed. All that we're doing is at this point making a recommendation to the full legislature either to include or not to include in the agricultural district. So I'm saying farming can continue, and I hope it does.
Well, and I hope staying true to our statement that we adopted in 2004 in protecting that activity in Putnam County also, while also protecting the neighbors and the residents. So it's a big, we're tasked with a big
It's
deal.
a catch-22.
So, yeah.
I mean, it all depends on which lens. Are
I,
we to increase farms, or are we to protect
Well, we're not increasing
existing?
them because there's activity happening on this property already, and there has been for hundreds of years. But I just wanted to make a statement. I am looking forward to the public hearing, and let's hash this out with the public as well.
No. Anything else?
I did have another item, I don't know whether we put it on the agenda for
Yeah,
now.
The last one.
Number
So we
9,
have to
yeah,
vote
we
on
did
the
vote
motion.
it. We did,
Yeah.
Diana,
Yeah.
okay. I
No,
move,
the Soil and Water Board he's talking about.
No, I'm sorry, I jumped ahead, I'm sorry.
Yeah, that's his other thing. You
So no,
gotta-
I'm saying,
You
but-
gotta do number 9
number
still.
9, okay.
Yeah.
I move to recommend not to include applicant number 9, Highview Farm, in the ag district. Do I have a second?
Second.
All those in favor?
Aye.
And, I'm sorry, were we okay discussing, I had one more agenda item, are we okay discussing that
That's up to
now?
the chairman. It's other business. It's the item that came in after the agenda went out, the Soil and Water Board members.
This is item number,
16A in the packet I gave you.
You could make a motion to take it.
You would have to make a motion to accept it.
okay, I'm looking for it right here.
Amended. the agenda to allow.
Do you have it? Because I can give you one.
I have it.
Okay, so first, make a motion to accept,
No.
to
Mr.
go out of
Chairman,
order?
Yes.
Okay, make a motion to go out of order and accept other business 16A at this time.
Second.
All those in favor? Aye. Neil, please.
This was just the last step in having our 3 board members approved for the Soil and Water Conservation District. We just had some turnover. We were fortunate to get 3 new volunteers, 1 from Phillipstown Conservation Board and 2 from the Ag Board. So I was just going to request that we get the board to approve those recommendations, or those approvals that came from Soil and Water.
And I have a question to both you and Legislative Councilor Villarroel, being that Mr. Garfinkel does not live in the county. Which position is he going to be filling, and is that acceptable?
That was there's two positions for the farm that should be representative for farmers, and 1 from some conservation background. Mr. Garfinkel is the current, he sits on the Phillipstown Conservation Board, and he's also employed as I forget what his title is, with the DEC. Yeah.
I just want to make sure, being that he does not live in the county, that we can accept him.
What position?
This is the conservation position.
And I remember, I don't have it in front of me, but I sent you the list of who can be, who's required to be a county resident. There's one that has to either be a resident or own rent or use property in the county.
Okay, and I want to make sure we meet that criteria.
And there's also in the AML, there's no mention of a residence requirement until you get to a 7-member board, and we're a 5-member board.
Okay.
I just can't advocate enough for Max Garfinkel. I watched him grow up into this position. I actually recommended his appointment to be the Phillipstown Wetlands Inspector. He's the Regional Natural Resource Manager for the New York State Office of Parks and Recreation and Historical Preservation, is the regional Palisades region. But if you look at his impressive resume, and he comes highly recommended from people in Phillipstown Town Board. He's been a great resource. I think you all know Phillipstown's attention to detail and land conservation, and he's at the forefront of it. So I think he'd be a great resource for this board.
I did ask our legislative attorney about this through the Ag Board, because I'm soil and water. And from what you sent, Rob, you said that the at-large context means a Putnam County resident, but a person has to, okay, so it doesn't necessarily have to be a person who resides in Putnam County. Is what I understood it to be. And I agree with Nancy Montgomery that his credentials are impeccable. We would be lucky to have him on our soil and water board.
Any other questions or comments? So I move to appoint these 3 gentlemen to the Soil and Water Board. Mr. David Vickery, Mr. Frederick Finger, and Mr. Max Garfinkel. Do I have a second?
Second.
All those in favor?
Aye.
Aye.
Thank you for your time.
Thank you.
Thank you.
Thanks, Neil.
Thank you, Neil.
Okay, number 5.
Thank you for the audience.
Yes, thank you for the audience. Number 5, Commissioner Barossa, you reached out regarding a county sale of a property at 100 Zimmer Road.
Several months ago, the adjacent property owner had reached out to myself as well as the county executive's office. Oh, sorry. So the adjoining property owner reached out with an interest to purchase this property. It's located off Pudsey Road, 100 Zimmer Road, in the town of Southeast, currently vacant. It was acquired from the town of Southeast as part of a land swap, I want to say 15 years ago. I believe the intent at the time was to use it for the animal shelter, Humane Society. As of now, it's not being used. The administration doesn't have a plan for using it. So the adjoining property, it basically surrounds this parcel, and it's proposed as a ball field complex called Brewster Yards. It would be run as similar to like a Cooperstown tournament venue, bringing in regional weekend activity, a ton of tourism, a ton of economic growth in the area. So at this point, I'd like the legislature to consider possibly disposing of the property, and with that, the county executive would prefer doing it by auction, but that decision is ultimately the legislature's.
Okay, that's interesting because my feelings, well, first of all, this property is going to be for economic development purposes, correct?
Yes.
Okay. So the two resolutions that accompanied the memo were not for auction. My feeling is I would like to see this property auctioned with a reserve. I think complete agreement. My gut just tells me that the appraisal is low, so I would like to auction this off with a reserve. Committee, you have any comments on this? Yes.
Mr. Chair, very important provision of the code that I have to point out in light of what Commissioner Perosa said about economic development and your question about economic development. There's a specific provision in the code that says, in no event shall any property be sold at private sale pursuant to this article for the purpose of promoting economic development, except for a sale through the applicable multiple listing service by utilizing the services of a licensed real estate broker. So I believe under the code, if the purpose of the sale is to promote economic development, it has to be through MLS.
Has to be through MLS.
That's what the code says.
Okay. Commissioner Lewis, you're saying yes? You're familiar with that?
That's the code, that's the code.
Yes.
This Brewster Yards is in my district, and it's a wonderful project comparable to the Field of Dreams up in Cooperstown. But I also, have a desire that the county gets the maximum amount out of the property, and whether it's an auction or we go through MLS. There can still be a bidding process through the MLS. So I'm in favor of moving this forward.
Anyone else? Yes, Elizabeth Nesser.
Is my understanding, and I don't have this confirmed, that dormitories are going to be erected on this property for guests? Is that the purpose of trying to obtain this property?
That's when the applicant came and presented the proposal to possibly purchase it. That was mentioned. At this point in time, we wouldn't have, the applicant would have to go back to the town if anything, any use of that property. Once it becomes private, they become subject to town law, going through site plan approval, seeker, all of that.
So what would define a dormitory versus a motel or a hotel? Because we're building a hotel when you exit away in Patterson, as you're aware. So what is a dormitory in this reference for this project?
So with baseball, so this is geared towards baseball. Baseball, 12-year-olds typically go to Cooperstown. and they stay with their team in a dorm. And it's a month. So they go and play games for a week. It's basically almost like a camp.
A bunkhouse.
A bunkhouse, yes. So that's what the idea was.
Where the
And
parents
the
go.
parents have to stay in hotels in the surrounding area and
Okay,
eat
they
at
can go
local
to Patterson.
restaurants.
Okay, I was unclear on what, that's fine.
Okay, like I said,
I'm
yes.
sorry. Do we have a comment from the town? I know it's not required, but with projects like this and our
We
authority.
don't have a comment from the town, but there was some unsubstantiated scuttlebutt that the town themselves might be interested in this property to use as a parking lot.
I would like to see a letter from the town with their opinion before we take it to the vote.
Well, I think before we even do that, we really need to come up with a price, because the resolutions over here said to list it at the appraised value, and 290,000 for commercial 10 acres property to me seems very, very low. And I want to make sure that the taxpayers get the best that they can. So we're right now on this for discussion.
Okay. And if the town is considering wanting this property?
Let them bid.
I think, well, I mean, in good faith, municipality to municipality, good neighbors and.
Well, I'll defer
It's just-
to the legislators from the town.
Well, it came to the county through a land swap, so the town's been compensated, and we use that, the town does use that property that they acquired. If they wanted to take this property back, either they can
Purchase it.
They can purchase it, or they can come up with another land swap.
And this is the first I've heard of them talking about a parking lot, but
Yeah.
I'll
I don't know
certainly
what-
follow up.
I don't know what they would use the parking lot for.
Yeah.
Well,
This was
parking
a
in any
wasteland
town.
piece of property.
The parking
Not
for
this
all
location.
the people for Brewster Yards.
Yeah.
It's a private enterprise.
Right.
The town has nothing to do with the private enterprise.
No, but from having children who have participated in these large sports things, that parking becomes a huge premium. And I could see how a very nearby parking lot, because we can be talking hundreds of cars, has commercial
Why
value.
don't we do it?
Right.
I don't know if we're in that business, but that's what I'm
The
saying
town's not in
is.
that business either.
Oh, through the chair, wouldn't parking be considered with the site plan evaluation when the project is being proposed?
Depending upon who
That's all
owns it,
part, the
absolutely.
equation is all part of the approval.
I'm sorry, my point is that there appears to be more than one interested party in this parcel. So let's let them,
Well, we
in
still have to
essence,
begin the MLS process at
yes.
this point in time.
I could certainly do my own homework and call the town supervisor and each board member to see what the, temperature is there with them and their feelings about this property. But I think it's in our best interest as neighbors and government officials to take them into consideration first.
I think Joe and Paul can do that.
Well, I can do it too, but it would be in the best interest of this committee to do it, I think, and have a formal memo sent to the rest of the legislature.
They're the representatives from the town.
Through the chair, the provision, I just want to be clear about something. The provision that I read about required to be through multiple listing, if it's for economic development, is in 31-8, which pertains to property obtained by foreclosure. And the reason I mention that is because the first resolution talks about selling it by auction, and I think you can only do a public auction for foreclosure properties. So I was assuming this was a foreclosed property, but the resolution, the first resolution that we received says pursuant to 31-4, which is the section of disposal of property by resolution, not by auction. There's a little bit of confusion in the resolution. So through the chair, my question is, was this a property acquired through foreclosure?
No.
All right, then I don't think it would be able to be done by auction to begin with. It would have to be done by...
With this, Connor, when he was still in the county, looked into it, he did tell us that we could do it by auction or MLS. So I'm not an attorney, but we can go back and speak to the county attorney about this.
Yeah, I appreciate that, because I think the only reference to auction is in 31.8 for delinquent, taken by delinquency.
Lynn Eckhart?
thank you again. I am on the Southeast Planning Board, and this is the first I've heard, I can't imagine it, for parking. Do you know what the zoning is there?
I do not.
Okay, because I think that would affect the price. Also, the one thing I might recommend, and I don't know, I would defer obviously to council and all of you, but over the years, not now, but quite a while ago, a lot more than just logs and things were dumped there. So I don't know who would have the liability on that, if there was asphalt and things like that, and whether you want to do test bores there before it's sold. And also, just so you're aware, I mean, obviously Brewster Yards can use it and it works for them and it goes through our process, that's just fine. But the traffic there with the closure of Pugsley right now, and I'm sure Joe and Paul have gotten complaints from their constituents, it's gonna be really, I don't know whether dorms go there or what, it's already really bad. And when Lincoln Logistics opens and Brewster Yards opens, which is thousands of cars on the weekend, that's something to take into account. But I would say multiple listing, if that is what you're supposed to do, probably, and I agree, it sounds like a very low estimate right now on price.
Sorry to be doing this on the fly, but just to be clear, I just double checked. 31-4, which is the regular section of conveyance, not the delinquent, has the same provision that if it's for economic development, it has to be, I'll just read it. In no event shall the legislature approve the transfer of any property pursuant to this section, and that's the section sale by resolution, which is not just delinquent properties, foreclosed properties. In no event shall the legislature approve the transfer of any property pursuant to this section for the purpose of promoting economic development, except when sold either to the highest responsible bidder after public advertisement or through the applicable multiple listing services by using the services of a licensed real estate broker. So it's the highest responsible bidder after public advertisement. If that means auction, then that's auction, but they do not use the word auction, whereas in 31-8, they specifically use the word auction.
So I think we need to clean up our resolutions, but I'm definitely in favor of liquidating this property. Looking around, yes?
I'm sorry, I didn't want to interrupt, but just wanted to point something out on the auction. The book that's here this evening, it says Putnam County, New York tax foreclosed properties. So that's all that's in the auction book.
Yes.
It says that, right?
This is something.
That's a previous auction.
No, I'm just talking about auction in general. That is,
But through the chair,
Yeah.
that's a different mechanism specifically for disposing of foreclosed properties.
Through
a
Article
different
11.
different
right,
auction process,
different
different
process.
auction, okay.
Again, I just would like to make the statement that I would hate to create an unwanted burden or scenario for the town, to be very conscientious of that. I know free enterprise is great and we'll sell it to the highest bidder, but what are we doing in consideration of the town if we do that, and the burden it will impose on them with more traffic, land use, craziness, I don't know. I'm not saying I'm not in favor of this, it just, I mean, they have their timeline all made out, their construction documents are already complete according to their website and their timeline, so hopefully, Brewster will be, the town of Southeast will be in favor of the sale.
Yeah.
I certainly agree that we should get some feedback from town supervisor and town council people. But our job is to get the best deal on this property, not worried about what the use of the property will be in the future. That's what the planning board is for, and I think that, we just need to stay in our lane here and get this thing sold for the most money.
I don't agree. I think these conversations can be hashed out and
Well, that's why.
relationships established between municipalities and the county.
That's why we're discussing this, and we will reach out to the town and we'll move along as appropriate, okay? So I guess there's any more discussion on this item?
And just also, from my perspective, just keep in mind that the ultimate goal is to get this back on the tax roll, and spread the wealth, so.
Okay.
Are we,
Well said.
We're just discussing.
It's just discussion.
Just discussion. Okay.
I would lean also towards MLS. I think that would be the best appropriate route for us, but that's just my opinion. But certainly would like to study it a little more, and I will definitely speak to the people in the town of Southeast just to see what their opinion is as well.
I agree with MLS.
Okay. Okay, I guess now number 6, Barbara. This is for a secret negative declaration.
So,
This is our ramp.
yes, lead agency was declared. There was a 30-day circulation to all of the involved agencies. Only one of the agencies responded. DASME sent back a letter saying they had no issues with the construction of the ramp at this county office building out at the front door with a new entry door. The reason for this environmental review was because it's adjacent to a historic structure, but typically this project would not rise to the level of requiring a review. So as a result, I have prepared a negative declaration. If you so feel that there are no environmental impacts, this could be considered.
Anybody have any questions on this? The proper way is to move this to the full, or just do an approval of the negative declaration here? Okay, I move that we move to the full for approval of the negative declaration for the county office building ADA ramp and entry door project. Do I have a second?
Second.
All those in favor?
Aye.
Aye. Thank you. And number 7, budgetary amendment to Maybrook Bikeway.
So the Maybrook Bikeway 2, Phase A, was constructed a few years ago, except for bridge number 5. That is the bridge right next to Brewster Honda, which had structural issues that were uncovered during the construction. So this was pulled out of the original construction project. We went back to design. Tried to go out to bid last year, only had one responsible bidder. So we went back to the drawing board, went out to bid again this May. We had a number of bidders. The low bidder looks very promising. Maria can speak to that as well. Unfortunately, the cost of construction has...
What was the engineer's estimate for the cost to do this project?
The original engineer's estimate that we had checked this winter before going to bid was $3.2 million.
And what did the lowest number come in at?
The lowest number came in at $4.9 million. And that does not include the construction inspection cost, which we need $652,000.
Okay, so we're looking at 5.5 million based on this. Who was the engineer who did the design? Did our plans inspect on this?
Chair B&L.
Okay.
WSP. Oh, sorry, WSP.
Okay. Okay, that's a huge difference. You know, it sounds like a worthwhile project. When I see an engineer miss an estimate by such a huge amount, it makes me question. That's just the nature of me in my professional capacity outside of here. We're paying for their expertise. Yes, there should be some increases, but we're way, way, way more than 10 or 15% beyond. So it's interesting. I'd like to see this project go forward. Is there any discussion or input? Joe?
Yeah, this is, I actually got a call about this bridge just yesterday. I mean, people really want it because I think it's vitally important also to the security in that area, because the bike path going towards Connecticut is not that safe right now. I know the sheriff's department was on the bike path today, and there was some issues going on, and Leah Honda is constantly complaining about it. I think if we have the bridge access there, it would be easier for the sheriffs to patrol through, and it would be a safer environment. So I do think we need to get this project moving along. It seems excessive just for a pedestrian walkway, but I think it would be vitally important to security, to the benefit of the community. I'd really like to see this project move forward.
Can I speak to this? There was also an incident a few years ago where someone accessed this location and actually fell through and died. So it speaks to the need for additional security and just activity in that area.
Right in the height of COVID, that happened too. I still couldn't figure that one out.
Any other comments?
Additional.
Yeah, it's additional.
Additional, okay.
Oh, yeah.
It's the budget for
I'm looking for that. Thank you, Larry. I move to accept additional number 7, budgetary amendment 24A074. Do I have a second?
Second.
All those in favor?
Aye.
Okay. So basically, we want to transfer out of the general fund, from what I see here, to add $1,175,000. Okay. If I may, Commissioner, Deputy Commissioner, DPW, have you guys taken a look at plans and specs on this?
Yes.
What's your feeling regarding necessary funds and/or modifications to make this a successful project and potentially control some costs?
Yeah, the structure is, it's not your typical bridge. There's only a few companies that even would be able to rebuild it. Basically, you're taking it down and putting it back up again. And there's only a few qualified companies that, we only had one company the first time bid on it. So that put us out 2 more years, hence the cost. Again, but being that it's such a tough design build, you're looking at higher numbers. It's going to take a while for the job, and I do agree with Legislator Castellano. Right now, it's a nightmare. We're spending a lot of time just in the DPW end of it, cleaning up. We were there 2 weeks ago, and that one stretch, we picked up 67 bags of garbage in one day. And I know the Sheriff's Department has been doing all sorts of taking all sorts of calls for up there also, so.
Okay. Anybody else have anything?
Can I just follow? I hate to ask this question, but time frame again, if this was to go forward? This year, as in?
Yeah.
As in this year?
Construction.
Wow.
As what?
Construction this year.
Construction this year, completion by?
It's a 9-month term.
9 months, yeah.
9 months?
So the sooner we get it, the better weather, the better chance.
Okay. Unfortunately, the bids go stale, so if we don't award by August 10th, we would have to go out to bid again, and construction costs keep rising, unfortunately.
Based on that, I would ask, because I'm going to make a motion to approve this, but I would ask that whoever is the proper party, please negotiate with the contractor and say this is what we can do now, else we have to rebid. Okay? I mean, hey, we gotta try, it's taxpayer money. Okay, I move to refer budgetary amendment 24A074 in the amount, capital expenditure $1,719,402, transferred out of general fund. $544,402 is from federal aid via the CARES Act, so fiscal impact to the county in 2024, $1,175,000, moved to the full for approval.
I think it's moved to audit.
Move to audit first?
Diane?
Yep.
This is moved to audit.
Okay, then please correct my move to audit. Do I have a second?
Second.
All those in favor?
Aye.
Okay, number 8 is for a budgetary amendment, 24A065 for guardrail damage compensation. I believe this was previously discussed. These are funds that have been recovered by Matt Bruno.
No, these are new ones.
These are new ones
Yeah.
that we've been recovered, but it says they're insurance recoveries.
Right, he went out, he got it, and this is money coming into the county.
Good. Well, thank you, Mr. Bruno, okay? Okay. So does this go to audit, is this, okay? I move to approve this and send to audit.
Second.
All those in favor?
Aye.
24A065, 9. Okay, this is for approval and implementation and funding for all costs of a transportation project. Croton Falls Road, Mud Pond Outlet, Culvert Rehabilitation in the town of Carmel. Qualified core costs can be reimbursed from Bridge New York funds. Tommy, can you please, Tommy and Joe, Commissioners of DPW, can you please let us know what we need to do?
Under Sheriff Linder said if I speak anymore, he's gonna trouble pay.
Nobody wants to be in that seat.
Musical chairs.
The music's done.
Guardrail, sorry.
No, 9.
Sorry.
Okay, so we're taking $2,632,924 from a capital budget line item, and made available to cover the cost of participation in the above phases of this project, okay?
These are the 2 culverts on Croton Falls Road. The original amounts we received in 2018 from the state, the Bridge New York funding program, were no longer sufficient for the tasks associated with the project, so we asked for, we went back and asked for money in this budgetary to compensate for the amounts that we think that these projects are going to cost in their entirety. And we will be entirely reimbursed through the Bridge New York funding program. So,
Committee, any questions?
Can we get that for the bikeway too?
Part of it.
Different source.
Nice idea. Okay, any other comments? This goes to audit? Or does this go right to the fall?
This one goes to the fall.
Okay.
Right, there's no budgetary, hold on.
Oh, there is.
Budget phase number 10.
Yep, comes after, number 10.
Okay, so I move to approve the implementation of this funding. Do I have a second?
Second.
All those in favor?
Aye.
Okay, and now number 10. This is what we just discussed. I move to forward this to audit for approval to the fall.
Second.
All those in favor?
Aye.
Okay, number 11, we're looking for funding for Peekskill Hollow Road, Peekskill Hollow Creek culvert replacement, town of Kent.
This was actually part of the same batch of 2018 solicitations to the Bridge New York program, as mentioned. So we worked with the DOT to commit the additional funding necessary to cover the entirety of these costs as well here. So we envision that the amount we're proposing here is going to be more than enough to cover the actual construction costs and construction inspection costs associated with the project.
Okay, so I move, any questions, comments? I move to approve.
Second.
All those in favor?
Aye.
Now, number 12 is the budgetary amendment, what we just discussed. So I move to approve, where is the budgetary amendment 24A072 in the amount of $1,840,000.00 to audit.
Second.
Second. Do we, well, before that, any comments or questions? No. All those in favor? Aye. Number 13, Joe, would you please enlighten us on this one, this Marquez-Selly program?
Marquez-Selly funds are the primary state aid matching program for locally administered FHWA projects, which typically amounts to 15%, which in this case it is, which will offset the local match significantly for this particular project, which is Fair Street, which is a substantial amount of money. So,
Okay, so this is additional funds, or are we drawing off the allocated funds?
this is offsetting the original 20% that the county had for this particular project, the county local match, I should say.
Okay. Any comments? No? I move to approve. Do I have a second?
Second.
All those in favor?
Aye.
Okay, 14 is the budgetary amendment 24A070 for the same Fair Street project. We're increasing appropriations by the total of $3,707,500. Of that, federal aid is $2,966,000. Any comments, concerns? Can I have a second?
Second.
All those in favor?
Aye.
Thank you, Joe.
Thank you.
Number 15, Commissioner Lewis. Tell us about all the money that you brought into the county here.
Have all the additionals also for that?
Thank you. Thank you, Diane T. I move to accept additional number 15. Do I have a second?
Second.
All those in favor? Aye.
Just getting myself situated here.
All right, so before we do this, anybody want to bet under or over $1.7 million? No, I'll take the over.
Okay. So let me just make a couple of general statements. Obviously, I want to formally introduce Mike Dean, who's part of my team. He's well-versed in the auctions. The last time we did an auction was during 2020. You know, one of the things, obviously, that, you know, what I've noticed since I've taken over is we are, unfortunately, we are, well, hopefully now were, one of the worst counties in the state when it came to filing tax liens. I was not very happy to hear that. We have about $30 million currently on our balance sheet. So obviously, according, to, Article 11, the real property tax foreclosure law, that gives the authority for myself to move forward and go through the foreclosure proceedings. Of course, there were a couple obstacles. There was obviously COVID. There's a moratorium. But needless to say, this auction sale, included 14 and 15 properties, lien properties. So even before the COVID, we were already about 3 or 4 years behind. So with that said, one of the first things that when I got into the big chair, I talked to Mike. We went over these properties. We spoke to Jen Herodes, who's our attorney in that regards into foreclosures. We spoke to Ed Vada, who's our title searcher, and since this auction, we're catching up. This obviously is the 14-15 sale, but and Mike can speak about this as well, but 2016 has already been filed with the courts. 17 is with the courts as well?
16 is actually complete, waiting for the deed.
Yep.
17 is filed beyond the redemption date, excuse me, waiting for the summary judgment to complete the foreclosure. At that point, Jennifer would file a deed for that. 18 title searches are complete, waiting for Jennifer Herodes to file the petition of foreclosure, and we are in the process of the 2019 title search.
So we are catching up. So it's very possible that the next auction, whenever that will be, will encompass the 16 and the 17 properties. So we are catching up. So that's the overall, gist of the overview. So, okay, so we had the auction a couple of weeks, what was it?
July 10th.
July 10th, the day before my anniversary. And that's why I wasn't here. And I think it was a very successful start. We, as you can see in the handouts, there were 161 properties that were auctioned. Of those 161 properties, 14 of them were not bid, which is in this lavender column here. There was, one second here. So there was bids on all these properties minus 14 of them. This, if you look at the last page, and we're going to go through, this is subject to change, but the bid amount for these 161 properties in total was $1.9 million. $4,446,000 is what, Mike, in Mike's world, it's called the deed book amount, but it's really the receivables, the old receivables on our books. There's a gain and loss column. The net amount is $2.2 million. But I do want to point out that of the 161 properties, 18 of them were sold for profit, shy of $350,000. The loss actually was like about 2.6, so that's where you get the net of the 2.2. The goal, from my perspective, from Mike's perspective, is we want to get these properties back on the tax roll, because at the end of the day, by law, we are responsible to make the towns and the villages and the schools whole, and we're left holding the bag, for better lack of words. If these properties were with other tax owners as of 1/1/24, all right, you would have had $7 million of assessed value back on the tax roll, and the tax rate would have been less. Spread it amongst all the taxpayers. We wouldn't be, we would have collected about $180,000 in school taxes, and that would be on the onus of the property owner, not the county. We would have collected approximately $72,000. So that's the ultimate.
So that relieves, basically what you're saying is, by disposing of these properties, we are relieving a tax burden to Putnam County of $252,000.
Yes.
Approximately. Okay.
And when you look, and what I want to drive home is that because these properties are the 14-15 lien, and we're technically 10 years behind, it's cost us $4 million to make the towns and the schools whole. So the towns and the school, they don't care. They don't care, to be frank with you. But I care. So that's why, I would urge the committee, to look through these parcels and, make a determination. I do want to point out, even though I think it was a very successful bidding process, believe it or not, the Lot 1 and Lot 5, I'd like to just talk to you guys about.
If I may.
Yes.
I met with these gentlemen, and they pointed out, Lot 1, the catalog incorrectly listed the property. This was reviewed. It does not appear to be landlocked, so it's potentially worth more. Additionally, it is potentially combinable with another county-owned property that is landlocked. However, the WAC agreement may come into play with these properties. So for a motion to accept this, we want to separate lot number 1. Okay. In addition, what we discussed is lot number 5 was a bidder error. where it sure appears that the bidder, it went from 1,500 to 160,000. So it looks like some extra zeros over there, so that to protect the error and the property, we're also not going to accept that property.
Correct.
Okay.
Chairman, we just learned actually, I think it was today, that not only was it an erroneous, zero added, but.
2 zeros.
It was 2 zeros, I'm sorry. The potential bidder actually thought it was Putnam County of Florida. So,
She purchased other properties thinking that it was Florida, so.
Property at a southern exposure.
Yeah, which is pretty interesting, because according to the terms and conditions, they're supposed to do their research prior to bidding, which is, from my experience, a big problem, because I've had multiple people come in, say, I bought a piece of property, is it buildable? And I was like, you're supposed to do that before you buy. So, it's traditionally the case in a lot of these properties, but let's hope that they're mergeable with an adjoining property owner and we won't see them again. That's the option, the optimum result. Just to mention, I think you're going to go on to we're on number 5. So, again today, I had a second bidder on number 5 come into the office. He realizes that the $160,000 bid was in error because we removed that bid per the email from the bidder to remove it. His claim is that he was the second bidder at $1,500. He followed the terms and conditions, and he would like to purchase that property as an adjoining property owner. Of course, I can't make that determination, that's up to you.
I think we have to put it out for bid, because the potential was, if it was a $1,600 bid, maybe they would have bid $1,700. So the fairest thing to do is put that property back out to bid.
Okay.
I'm
sorry. Who?
Oh, no, I just wanted to ask, how long would they have to wait for that, the next auction then?
That's a good question. We don't know that yet.
We don't know that yet. I mean,
it could be next year. Yeah, because we don't have deed for 16 yet. We don't have deed for 17 yet. So it's most likely going to be next year. And then we fall into the new Article 11 legislature that we're still working on. The whole process there.
To be fair to everybody, could we, without publishing, in a hard copy, et cetera, just auction off that property?
Like a one-off?
But you have this, I'm sorry, through the chair, but you have this one person that's,
Yeah, let them bid on this property. Yes.
I'm not clear on this. So what we have here is a landlocked parcel which is contiguous with the prospective bidder who wants the property for $1,500, which will take it off, put it back on the tax rolls, but we're going to go through this whole process because we might get $100 more?
I don't believe Lot 5 was part of the landlocked, it was just another.
It says
bid.
landlocked parcel?
It was?
It is landlocked, yes.
Okay.
And I actually have a map here which I could hand out.
I think
It is not landlocked?
the question is,
Number 5 is one.
Yes, it is. That's what we're talking about.
Legislative Council, could
So
you
the
wait?
bidder, the second bidder, who is asking for consideration, this property is contiguous with his land. So I think it would behoove us to accept that bidder, because there really is no market for a parcel that is not suitable for building.
Rob, could you weigh in on this, please?
Well, the first thought I had was, I had spoken with Commissioner Lewis about this, and in the case where there's an error in bidding, the county code says that the commissioner and the county attorney have discretionary power to deal with anything procedural or administrative with an auction. So if they deem that that the auction was blown up by this bad bid, they would have the authority to rerun the auction. The only little hitch in that is now hearing that the second bidder has come in and asked to buy it. I don't know, I haven't seen the terms and conditions of the auction. If they had a right as the next highest bidder in the event the first person defaults to purchase it at that price, that may be something that the law department's going to have to weigh in, whether that person has a legal right to purchase at that price. I don't know the answer to that because I don't know the terms and conditions of the auction. I just wouldn't want to expose us to a lawsuit by somebody who said, hey, the terms said that, you know, the highest actual bidder who's ready to bid can exercise the option if the highest bidder doesn't come up with the money. So
We're going to have to get an opinion from the county attorney, but I thought in here...
Procedurally, we've done that in the past. If the original bidder defaults, doesn't close, whatever reason, we do go to the second bidder.
the kind of hitch here is that the auction did not go to its
maximum
potential because of an error. So that's kind of a gray area.
Yeah.
Well, could they, could they just ask them to give $1,600? It's only $100 more. Then it would be the
The
highest
issue
bid.
is, because the auction terminated, what was it, like an hour and change before its end time?
Yeah, the second bidder, I don't have it in front of me right now, but the second bidder, excuse me, this $1,500 bidder, I think bid at like 9:30-ish, give or take. And then that $160,000 bidder was at 11 o'clock, and everything closed at 1:30.
So for an
So
hour
we
and
could have technically, you know.
If the bidder who bid the 160 had bid 1,600 correctly, theoretically, there could be bidders who would have bid 2,000, 3,000 in that hour and a half.
Right.
You really don't know what would have happened.
I just,
You're saying now that one of the bidders was a contiguous property owner?
Yeah.
Yes.
Why weren't they given a chance to buy this for what the auction?
Because
Don't we
typically we do, but I think we're required to put it to auction and not be arbitrary.
Did he have a chance to buy it at one point in time?
It was never offered, he never came forward.
Okay.
We would typically say, we're having an auction, it'll be in the auction, you have a chance to bid on it at that point.
I would have a suggestion going forward, because once we take title to these properties and we start paying the school and the town, especially if it's a landlocked property and looking at the assessed values, at some point, somebody should go into the towns. And as an assessor in Putnam County for many years, nobody ever came to me and said, you gotta look at this. You get this property assessed at $100,000, it's landlocked, nobody wants it.
Yeah.
Okay, and if you had to go to grievance, you had to go to grievance. I would think that the assessors would be willing to work with you.
I would think that, and I believe the former Director of Real Property would do that.
I worked as an assessor here for many years, she never came to me.
She never came, okay, so that was my thought, that that's who would do that. I think she did that in other cases. I don't know if she did it on a one-by-one basis, but I think that was the case. I know that property was reduced in certain cases, maybe not all of them.
Yeah, but it would be good to put a package together, you have everything laid out by town, and just make an appointment with the assessor and say, here, this is what we have, what do you think? If they're not willing to work with you, then you file grievances.
so, it just begs the question, what's the argument here if we have a lot that is not substantial, that doesn't meet any criteria to build, and we have a bidder who is willing to pay $1,500 and the land is contiguous to get it off the roll, time is money, with the hopes that we might get someone who's going to bid $1,700. I mean, it just sounds penny wise and pound
Yeah,
foolish.
except there were 5 bids, correct, on that property from 3 or 4 different people, and
Do they understand it's a substandard lot? It's a
From the
substandard
We're
lot.
supposed to do there.
what the question is, I agree with you, the question is, do we have any exposure by doing it?
Well, I
That's
think
the
we should
question.
ask the law department for their opinion. because-
Yes, which is why I want to separate that lot out from we have to approve ratification here, and the way this is written, it's for all parcels, and I want to amend this to exclude certain parcels so we can get that done.
I have a question. And I always thought we did this, but maybe I'm wrong, and it's along Legislator Yankee's question. I thought whenever we had a property that we were considering foreclosure, we would at least notify the neighboring property owners to see if anybody would have wanted to purchase it before it went to auction. Is that something,
Well,
I know we've done it in the past, because
we have done it. The last time we did an adjoining property sale was 2015. Obviously, when we went to the auction process, we want to make the auction as favorable as possible, so the idea is to give it all to the auction company to make the, because you don't want to give the auction company half the parcels. I understand what you're saying is we want to merge them and all that, that's great, but we also want an incentive for them to come and do the auction for us. And these properties are automatically merged through the auction.
if the neighbor
Yeah, I
property
mean,
buys it.
Also, yeah, and we have to make sure that they're not the owner, previous owner.
Right.
Because a
Because
lot of
they're
times
beating
they
the
are.
system.
They are, so we have to put it out, you know.
Well, that makes sense.
Yeah.
That person would be precluded from
And
purchasing.
typically, when we had an adjoining property sale back, even before my time, they were offered at $10.
Right.
You know, so, which, it puts it back on the roll, but you're not getting 1,600, you know, so it's, you know,
Rob, do
it
you
just
have any
decide, you know.
suggestion?
No, except you said that you intended to
Bite and
separate out those
Yeah,
parcels.
because I'd like to get that, and maybe we could take a, okay.
Through the chair, Adam, there were quite a few landlocked parcels. Do you know if it was contiguous and that particular owner purchased these?
I do not know as of yet.
Because I can't see why anybody would buy them if you can't build
That doesn't make sense.
That's, and if you see, most of the purple, the lavender marked ones are landlocked.
Right.
So,
But I'm asking who purchased them?
That was, yeah, that's on the, that's not on this.
No, I'm just wondering if it's the owner.
I'm hoping that they are.
That's- okay.
Yeah,
All right.
yeah, I'm hoping that they are. We don't have the full, this is like just the initial
Okay.
auction. We're supposed to get the actual down payment, because we don't even know actually if these all came in and made down payments.
Right.
We don't have that information yet.
How much does the auction company get out of this?
I believe they get 7%
7%.
of the,
Not bad, I mean, not bad for us. I mean,
yes, I think John Tully negotiated their percentage. I believe it's 7% of the purchase price.
Okay. So, any other questions? Okay, so what I would like to move forward for approval and ratification, Rob, it's as printed here, except I would like to modify line 2, whereas the county received bids, partial offers indicated by the listing attached here to may do part here of a Schedule A, except for lots 1, lots 5, and these following lots are lots where we received no bid: 44, 70, 80, 89, 90, 93, 94, 126, 128, 129, 142, 144, 150, and 152.
And number 5 is actually not on Schedule A because of that procedural issue.
Okay, so it's not. So the proper motion for that,
The motion to amend the resolution
Okay.
in accordance with the lots you just deleted.
okay?
Or to amend, I shouldn't say, correction, not to amend the motion, but to amend the schedule.
Okay? So, motion necessary, just amending of schedule?
Motion to amend the schedule.
Okay, I'd like to, okay, I move to amend Schedule A to delete from subschedule lots 1, 44, 70, 80, 89, 90, 93, 94, 126, 128, 129, 142, 144, 150, and 152. Do I have a second?
Second.
All those in favor?
Aye.
Okay. Now I move that we approve and ratify the 2024 real estate property tax sale based on the amended schedule.
Second.
Second. All those in favor?
Aye.
Thank you. And
That's it.
that's it. Seeing that there's no additional other business, I move to adjourn. All those in
Second.
favor? Aye.